I request you to settle down the guests in the Good morning, everyone. On behalf of NVT Law College, it is my proud privilege to welcome you to this law lecture series in the memory of our beloved late Sir Dr. M.S. Gosavi, former Secretary and Director General of Gokhale Education Society. Today's event is a confluence of knowledge, inspiration, and judicial wisdom. We are truly privileged to have among us a very distinguished personality, Honorable Justice Shri Abhay Srinivas Oak, former Judge of Supreme Court of India. We have with him on the dais Honorable Dr. R.P. Deshpande, President of Gokhale Education Society, Principal Professor Dr. H.I. Kadri, and Vice Principal and Coordinator of today's program, Professor Dr. S.K. Mandavkar. Let us welcome them all with a big round of applause. Late Sir Dr. M.S. Gosavi was the true backbone of our Gokhale Education Society. A visionary in every sense, he became the youngest principal at just 23, earning a world record for his remarkable tenure. Sir's passion for law, society, and academics was profound, and his absence has left a deep vacuum. It is our obligation to carry forward his thoughts, values, and lasting legacy. To honor his extraordinary life and contributions, we initiated the Sir Dr. M.S. Gosavi Memorial Law Lecture Series. Through this series, distinguished speakers are invited to share deep insights on contemporary legal, social, and academic issues, enriching our knowledge and shaping our personalities. To tell us more about this, I welcome the visionary behind this law lecture series who transformed the idea into reality, our principal, Professor Dr. H.A. Kadri. May I request Sir to address the gathering with a welcome speech?
Very good morning. Respected Honorable Justice Shri Abhay Srinivas Oak, former Judge Supreme Court of India, respected President of today's program, Honorable Dr. R.P. Deshpande sir, President of Gokhale Education Society, other representatives of the management, my colleague Dr. S.K. Mandavkar, Vice Principal of the college and Coordinator, esteemed members of faculty of this college, faculty of other colleges, principals from various law colleges from Nashik, representatives from media, professors, colleagues, dignitaries, and my students. It gives me immense pleasure to welcome you all to this Sir Dr. M.S. Gosavi Memorial Law Lecture Series, an important academic event organized to commemorate the life and enduring contribution of Sir Dr. Mose Gosavi, an eminent educationalist and institution builder. We are deeply honored by the presence of Honorable Justice Shri Abhay Oak sir, former Judge Supreme Court of India. Your Lordship's distinguished judicial career, marked by constitutional fidelity, independence, and integrity, lends great dignity to this occasion. We are grateful to Your Lordship for consenting to deliver the memorial lecture on the relevant and timely topic, challenges before the judicial system after completion of 75 years to the Constitution. Sir Dr. M.S. Gosavi was not merely an academician or administrator. He was a visionary educationalist who believed that education is the foundation of a just, disciplined, and progressive society. He dedicated his life to the development of educational institutions, the nurturing of young minds, and the promotion of values such as integrity, responsibility, and public service. He strived for affordable and accessible education to poor and needy people. As a teacher and mentor, Dr. M.S. Gosavi inspired students to strive for excellence not only in learning but also character. He believed that education must produce enlightened individuals capable of critical thinking, guided by ethical values and committed to the welfare of the society. His emphasis was always on discipline, intellectual honesty, and respect for constitutional and democratic values and ideals. As an administrator and institution builder, Dr. M.S. Gosavi laid strong foundation by insisting on academic standards, research orientation, professional ethics, and institutional discipline. He firmly held that educational institutions must serve society by producing responsible world class citizens who are sensitive to social realities and committed to justice and equality. What distinguished Sir Dr. M.S. Gosavi was his humility, simplicity, and lifelong dedication to the public good. He served this society his whole life. He had been secretary of this Gokhale Education Society for 50 years. From one institution to 143 institutions, he worked day and night and took his last breath while working for the society. He passed away on 9th July 2023, leaving behind his legacy of guidance, inspiration, and thoughts, as well as the ideals of justice and equality. Despite his achievements, he remained accessible and deeply concerned about students and larger social purpose of education. His life demonstrates that education, when combined with values, becomes a powerful instrument of national development and social welfare. A relevance of Sir Dr. Mose Gosavi Gosavi sir's ideas is specifically significant as we reflect upon 75 years of the Constitution of India. At a time when the judicial system faces evolving challenges, the role of constitutional institutions and informed citizens becomes critically important. It is therefore most appropriate that this memorial lecture is delivered by Honorable Justice Abhay Srinivas Oak Sahib, whose judicial contribution reflect a deep commitment to the constitutional principles and the rule of law. We are confident that your Lordship's address will provide valuable insights and inspiration to our students and faculty. Today's program is not merely a tribute to the memory of Sir Dr. Mose Gosavi, but a reaffirmation of the values he stood for: excellence in education, institutional integrity, constitutionalism, and service to the society. The continuation of this memorial lecture series stands as a tribute to his enduring legacy. In conclusion, I express my sincere gratitude to Honorable Justice Abhay Oak Sahib for gracing this occasion and sharing his wisdom with us. I also thank all the dignitaries, specifically the President of today's program and President of Gokhale Education Society, Honorable Dr. R.P. Deshpande sir, all the principals, faculty members, students for their presence. Let us honor the memory of Sir Dr. M.S. Gosavi by upholding the values he cherished and by committing ourselves to education that serves the nation and strengthens constitutional democracy. Thank you, one and all.
Thank you, sir. Thank you, sir. Your words have truly set the tone of the evening. It is my privilege to introduce today's keynote speaker, Honorable Justice Abhay Srinivas Oak, a jurist known for clarity of thought, firmness of principles, and a lifelong commitment to constitutional values. Your Lordship has done BSc LLM from the University of Bombay. Sir enrolled as an advocate on 28 June 1983. He started practicing in Thane District Court in the chamber of his father, Srinivas Oak. In 1985 to 86, he joined the chamber of Honorable Shri V.P. Titmus, former judge of the Bombay High Court and former Lok Ayukt. He appeared in several important matters and in public interest litigations. Honorable Justice Oak was elevated as the additional judge of the Bombay High Court on 29 August 2003. He was appointed as the permanent judge from 12 November 2005. Sir took oath as the Chief Justice of High Court of Karnataka on 10th May 2019, and he took oath as the Judge of Supreme Court of India on 31st August 2021. Your Lordship, marking the conclusion of an extraordinary judicial career spanning more than 4 decades, retired on 23rd May 2025. We are truly honored to welcome you, sir. To express our respect and gratitude, I request Honorable Dr. R.P. Deshpande to felicitate Honorable Justice Shri Abhay Oak, sir, with a token of our appreciation. Thank you, sir. As a representative of our Gokhale Education Society, We are extremely honored by the presence of Honorable Dr. R.P. Deshpande sir. Dr. R.P. Deshpande, the President of Gokhale Education Society, is always with us and guides us in all our endeavors. I request Honorable Justice Shri Abhay Srinivas Oak to felicitate Honorable Dr. R.P. Deshpande sir. Thank you, sir. Now I request our Honorable Principal, Professor Dr. H.A. Kadri sir, to felicitate Dr. Charushila Karanar, Principal of SPH Law College, Panchpati. Thank you, sir. I request Vice Principal of our college, Professor Dr. S.K. Mandalkar sir, to felicitate Dr. Sandhya Gada Madam, Principal of MVP Law College. Dr. Sandhya Gada Madam, Principal of MVP Law College. We acknowledge the presence of all the invitees, teachers of other law colleges and advocates of Nashik Bar Association. In celebration of National Education Day, observed on 11th November every year, to honor the birth anniversary of Maulana Abul Kalam Azad, NBT Law College conducted the National Essay Writing Competition. Several students participated in the competition and 3 of them have secured position. I request the students to come forward and receive the certificate and prize money. Third position is secured by Sagar Ushire. I request Honorable Dr. R.P. Deshpande to give away the certificate and cash prize. Please stand. The second position is secured by Khushi Bhat. I request Honorable Dr. Justice Abhay Srinivas Oak sir to give away the certificate and cash prize. And the first position is secured by Gosia Mania. I request Honorable Justice Shri Abhay Oak to give the certificate and cash prize. Thank you, sir. A big round of applause for all the winners and participants. The participants of the event are requested to collect the certificates from Sonali Govind Madam after the program. Today's event is celebrating the 75th year of the Constitution, and the Judiciary, as an upholder of the Constitution, plays a pivotal role in preserving and enhancing the rights and values enshrined in it. It is my honor to invite Honorable Justice Shri Abhay Oak to deliver his lecture on the topic Challenges Before the Judicial System even after 75 years of the Constitution. Your Lordship's insights, grounded in rich judicial experiences, will undoubtedly enlighten and inspire each one of us. I welcome him to enlighten us.
Good morning. I am so glad to be here after 17 to 18 years. I remember it maybe in 2007 or 2008. I was here on the occasion of moot trial competition. Dr. Deshpande, Professor Dr. Kadri, principals of various law colleges in the city, members of the faculty, members of the bar, and student friends. I have seen a great transition in our legal system as well as in the system of legal education. I was admitted to Government Law College in 1980, July 1980 to be precise. Government Law College is the oldest law college in our nation. Those were the days when law was last choice of the students. It was said in those days that those who could not secure admission to professional courses, last resort was education in law. And those were the days where all law courses were 3 years courses and part-time courses, either in the morning, afternoon or in the evening. And we used to have maximum 2 or 3 lectures every day. There were hardly any competitions like moot court competitions. We had not heard of this mock trial competition, other competitions. From 80s, law education underwent a change with the advent of 5 years course. And I can say that now talent has come back to law, and talent has come back to law in a great way. During my office, while holding office as a judge, I must have traveled to various law schools and colleges across India, and I can see the talent in the law colleges. I used to have about 6 to 7 interns every month in Supreme Court, and I was really fascinated by the enthusiasm, talent and knowledge of the law students. So it's a great change which I have seen during last 43 years. I also seen changes in our judicial system. Now today we are discussing challenges before our justice delivery system or judiciary 75 years after Constitution came into force. It is not as if that courts were not in existence in our country. As some of you know, that the British government or the Crown in those days established Supreme Court at Mumbai in 1823. And there is a very fabulous history to Supreme Court in Mumbai. There was a Chief Justice by the name Sir John Peter Grant. On 1st April 1829, he threatened to close the Supreme Court on the ground that the writ issued by him was not honored by the then Governor of Mumbai, Governor of Bombay in those days. And he threatened to lock the premises of the Supreme Court and go back to England. Then the case was carried to Privy Council and rest is history. Then comes Bombay High Court. On 26th of June 1862, latest pendant was issued by the Queen, under which Bombay High Court was established. It was followed by Kolkata and Madras. Civil courts and district courts in Maharashtra have long history. In fact, civil courts and district courts were established in Maharashtra under the Act of 1869, Bombay Civil Courts Act 1869, which still continues to operate with so many amendments. And criminal courts were largely established after 1898 Criminal Procedure Code came into existence. And those were the days when there was no separation of powers. In those days, even the district collectors and even Mamlatdars or Tahsildars, they had judicial powers on the criminal side. The change was brought about firstly on 15th of August 1947 and then 26th of January 1950 when Constitution came into force. Under the Constitution, Supreme Court of India was established, and all courts, including high courts which were functioning earlier, maybe under latest pattern, maybe under local laws, they started functioning under our Constitution, Constitution of India. And therefore, this is the relevant date for our judiciary. The reason is, in the preamble to our Constitution, citizens were assured justice, social, economic and political. And please remember that unless our justice delivery system represented by courts delivers quality justice, quality justice, the assurance given by the framers of the Constitution to give justice to the citizens cannot be fulfilled. Now let us understand what is the scenario with our judicial system. If you talk to any common man about the Indian legal system, he would refer to a famous dialogue in Hindi movie of 90s. The dialogue was attributed to Sunny Deol, and the dialogue was, what you get in our courts is Tariq pe Tariq. So this is the reaction of the common man when we talk about the courts. Of course, there is a lot of misunderstanding about the way courts function, why dates after dates are fixed, and I am going to explain that to you today, what are the reasons for that. But the fact remains that common man is not satisfied about the services rendered by Indian judicial system under the Constitution of India. Now fortunately, the status of judicial system can be seen on a website known as National Judicial Data Grid, where all the figures of pendency of our trial courts, high court, Supreme Court will readily find there. And now you can imagine what is the status of our judiciary. I am giving you figures of yesterday. Today morning, if you check it, it will give you latest figures. Now first, let us talk about our trial and district judiciary. Now the pendency is 4.88 crore cases across India in our trial and district judiciary, out of which 26%, approximately 26%, are 5 years old. And out of this 4.88, about 1.11 crores are 1.11 crores are civil cases and 3.77 crores are criminal cases. Let us look at our high courts. The total pendency as of yesterday in our high courts was 63,58,000 cases, out of which 44% cases are more than 5 years old. Then let us talk about state of Maharashtra. In Maharashtra, in our trial and district judiciary, the total pendency is 59.71 lakhs and 24% cases are 5 years old, out of which about 42 lakhs are the civil cases and 17.66 lakhs are the criminal cases. Nashik district, where we are sitting today, has also a major share in pendency. Nashik district has pendency of 2.67 lakh cases, out of which 27% are more than 5 years old. Then let us talk about Bombay High Court. As I said, in all high courts in India, total pendency is 63 lakhs, out of which more than 10% is contributed by Maharashtra, that is Bombay High Court, with its benches at Aurangabad, Nagpur, Goa and Kolhapur. That pendency is of 6.67 lakhs, out of which 48% are more than 5 years old. I have been part of the legal fraternity for last 43 years, about 20 years as a lawyer and then for about 22 years as a judge. One thing I have not seen is decrease in filing and pendency of cases in our courts. This is something which is ever increasing. And in a lighter vein, I am going to tell you for benefit of young students. This is one reason why legal profession is said to be the most lucrative profession in India. If you talk to doctors, if you talk to architects or chartered accountants, they will tell you that legal profession is the most lucrative profession. When I talk to the law students about prospects or career prospects in traditional legal practice before our trial and district courts or high court or Supreme Court, Of course, I tell them about the difficulties faced by first generation lawyers because there is a waiting period of 1 or 2 years or 3 years. But these figures will show that there is a place for everyone in our traditional legal practice. There is so much of work in all courts. During last 20 years, number of courts have increased, number of tribunals have increased. And mind you, when I have given you these figures do not include the figures of pendency before our tribunals. Now, for example, we have State Administrative Tribunal and Central Administrative Tribunal, where the petitions filed by central and state government employees are tried. There are other tribunals, Maharashtra Revenue Tribunal, then there is National Green Tribunal, there are tax tribunals, Income Tax Appellate Tribunal, GST Tribunal, various tax tribunals, a Securities Appellate Tribunal. So we are not even discussing pendency of cases in those tribunals. Now, what are the reasons for this huge pendency? When so many cases go to the court, and especially criminal courts, that shows the status of our present society. Because you will find that, keep aside Maharashtra broadly speaking, the pendency on civil side is much more than pendency on criminal side. But if you see the pan-India picture, I told you the pan-India picture, the major pendency is on the criminal side. This also shows that the crime rate in our society, in our country, is ever increasing. And that is what is reflected in filing of cases before the courts. Very interestingly, I tell you how society or changes in the society contribute to filing of more and more cases and pendency. Naturally, if there is more filing, there is more pendency. During last 25 years, in our society, especially in cities in Maharashtra, we have witnessed that there are large number of matrimonial disputes which were not there, say, about 30 years back. And these matrimonial disputes are threatening our judiciary. Threatening in what sense, I tell you. If there is one matrimonial dispute, a dispute between husband and wife, then there are one or two cases under the traditional laws, namely the Hindu Marriage Act or Special Marriage Act, maybe for divorce, maybe for restitution of conjugal rights. Then inevitably there is one criminal case filed by the wife alleging cruelty against the in-laws, husband, etc. Then there is a maintenance case filed by the wife. There are cases under Domestic Violence Act filed by the wife. Unfortunately, to that married couple, there is a child, then there are cases for child custody. And recent trend which I have noticed during last 5 to 6 years is due to use of technology. Husband and wife who are having practically a war, they exchange WhatsApp messages, and on the basis of WhatsApp messages, either husband or wife, they file prosecution under the IT Act on account of those WhatsApp messages. So now in our state and many other states, one matrimonial dispute creates 5 grassroots level litigations in 5 different courts. And then there are revisions, appeals, writ petitions, etc. up to Supreme Court. Of course, this all works for the benefit of lawyers. Long time back, about 24 or 25 years back, there was a lecture in Bombay University by very eminent lawyers. So one of the lawyers said that, look, I'm talking about somewhere in 99 or 2000 when I was a practicing lawyer. One great lawyer said that, look, anything which happens in our society serves well for the profession of lawyers. There are riots, there are other things, there are frauds. The lawyers is one community which is benefited, but it puts enormous pressure on our courts. Now, I give you these figures. Now, one reason why we have this huge pendency, as I said, is the situation at grassroots level in our country. There are so many crimes and new offences are being created. For example, some of you must have read, about 10 years back in Bihar, they brought about a prohibition law. there is a complete prohibition on manufacture, sale and consumption of liquor, barring few exceptions. When we took a survey, as a result of that law, the pendency of bail applications in courts in Bihar increased by 25 to 30% by only one law. There is one more law, or rather amendment to law. You are aware about Negotiable Instruments Act. Section 138 was incorporated few decades back, by which bouncing of check was made an offence. Actually, it is a civil wrong that I issue a check and that check is dishonored. It's a civil wrong. But our legislature has converted that civil wrong into a crime. And therefore, there are a large number of cases. You go to criminal courts of magistrate in Nashik, go to any big city in Maharashtra, you will find that 30 to 40% cases are under Negotiable Instruments Act. So to say so, there are new crimes which came into existence by virtue of various legislations, and therefore there is more pendency in our courts. One striking reason for this huge pendency and this tariq pe tariq, I think some of you must have visited the courts and you will find, I am talking about our trial and district courts, especially trial courts, civil courts and magistrates court. You will find outside the court or even the website of the court, there are long cause lists. For example, if you go to a Metropolitan Magistrates Court in Mumbai, you will find 100 cases listed. Same thing must be happening here before the Chief Judicial Magistrate and other magistrates. Now, if there are 100 cases or 70 cases, 75 cases every day, obviously the court can deal with very few cases because trial courts have to record evidence, the examination chief and cross-examination. Now, why this is happening? There is a concept known as judge to population ratio. So, how many judges should be there for population of 10 lakh, that is 1 million? In 2002, Supreme Court dealt with a case where it was brought to the notice of the Supreme Court that in USA, judge to population ratio was 101, 101 judges for population of 10 lakhs. In UK, it was around 60. In Australia, it was again about 90 or so. In various developed countries, it was well above 70, 60 or 70. Even today, in UK it is 51 and in USA it is 107. 107 judges per 10 lakhs. So in 2002, Supreme Court noticed that in India, there are only 13 judges, 13 judges for population of 10 lakhs. Therefore, Supreme Court directed that within 5 years, judge to population ratio in India should be increased to 50. That was done in 2002. So by 2007, we should have 50 judges for population of 10 lakhs. After that, as I said, number of new litigations are coming up. Maybe more matrimonial cases, this prohibition law cases, domestic violence act cases. And today, I am talking about official figures. I think a year back, Honorable Law Minister on the floor of Lok Sabha said that just to population ratio in India today varies between 20 and 22. So in 2007, we should have 50 judges for population of 10 lakhs. Today, we are struggling at 20 or 21. And between 2002 or 2007 and 2025, the population has enormously increased. The new cases which are being filed have increased. But still we are struggling at this low percentage, that is low just to population ratio. Unless we have this kind of a just to population ratio, so at least 50 per 10 lakhs, we will see the same set of figures and we will see in fact ever increasing figures of filing and pendency. Because essentially pendency increases firstly because there is more filing and secondly because we don't have adequate number of judges. I forgot to tell you the figures of pendency in Supreme Court. When we began in 2025, the pendency was around 84,000. Now even the Supreme Court pendency has crossed 90,000. It's I think 91 or 92,000. There is another reason. You know, you must have. I began by saying that tariq pe tariq. Now there are criminal cases which are conducted, and you will find that the procedure is long in criminal cases. In the sense that, broadly I tell you, in the sense that FIR is registered, then police investigate, police or other investigative agencies investigate, they file a charge sheet before the magistrate's court or some special court, then the court takes cognizance and then charge is framed. And only after charge is framed that trial starts. Trial starts by examination of witnesses. So the prosecution examines the witnesses and they are cross-examined by the lawyers representing the respondent, the accused. So this cross-examination takes long time. The reason is the lawmakers in our country realize that police can misuse the power given to them. There are cases and cases where we find that though there is no evidence at all against the accused, people are framed, they are tried. In fact, sitting in High Court and Supreme Court, in some criminal appeals, I have granted acquittal, clean acquittal, not for benefit of doubt, etc., clean acquittal in many cases where accused has undergone sentence for more than 10 years, sometimes 15 years. So this is the tendency on the part of the police to frame people, because police machinery is also overburdened. What I talked about, the low just to population ratio, the police personnel, number of police personnel are on the lower side. We need more and more police personnel in our police force. That is not happening. And therefore, we have Article 21. Article 21 guarantees fair trial to everybody. And therefore, we have the principle of presumption of innocence. There are exceptions to that, but accused is presumed to be innocent unless his guilt is proved on the basis of evidence beyond reasonable doubt. So these principles are consistent with Article 21, because Article 21 says liberty of any individual cannot be taken away without due process of law. Virtually the due process of law maxima imported from USA. And therefore we proudly say that Ajmal Kasab, who was one of the only accused who was found in that horrible incident of 26 November in Mumbai, he was also given very fair trial. He was given a lawyer, legal aid lawyer. When his death sentence reference came to High Court, you know, some of you must be aware that if death sentence is awarded by our Sessions Court, it cannot be executed unless it is confirmed by the High Court. So that confirmation case, High Court appointed a very seasoned lawyer on the criminal side to defend Ajmal Kasab. And young students, you must remember one thing, difference between Article 21 and Article 19. The fundamental rights guaranteed under Article 19 are available only to citizens. But fundamental rights under Article 21 are available to anyone, he need not be a citizen. Therefore, we gave a very, very fair trial even to Ajmal Kasab. Our system ruled out possibility of that person being framed in that offence. There is another reason why this happens. During last 10 years, we have witnessed a very peculiar thing. The reluctance on the part of young and bright law graduates to join traditional legal profession. They eye on jobs in the firms, they eye on jobs in corporate sector, but very few join the traditional legal profession. Because if legal system is to succeed and work effectively, we need very competent lawyers, and competent lawyers in large numbers. That is not happening. Therefore, last about 10 years, I have undertaken this mission. Wherever I go to any law college, I impress upon the students the necessity of joining legal profession. Secondly, I talked about low judge to population ratio. But there is another side to it. That side is that, so we recruit the judges firstly at the level of civil judge come judicial magistrate, where after 3 years practice, a young law graduate who is more than 25 years of age, he can appear for the competitive examination, appear for interview, and he gets selected as a civil judge. And after putting in 7 years of practice, by again appearing for competitive examination and interviews conducted by the High Court, you can be appointed as district judge. Almost in all High Courts, the experience is that when we advertise, suppose we advertise say 50 posts, in one process we are not able to fill in all the posts, 100% posts. And therefore those processes are conducted repeatedly. So this shows reluctance on the part of young lawyers to join judiciary. Here I want to tell that so many young students are there, and especially girls are here. I want to tell you that now the service conditions for judicial officers at entry level are very reasonable, in the sense that if you enter judiciary after 3 years of practice, you may be 26 or 27, you are 25 also if you join practice immediately after you become graduate. Now the starting pay after deduction of income tax which a judicial officer gets with only 3 years of experience in practice is 95,000 in hand, plus all the perquisites. There is a driver's allowance, there is children education allowance, there is rent-free quarters, then there is medical reimbursement, you get laptop, you get iPad, you get Supreme Court cases subscription. So very reasonable pay structure is now available to a young law graduate who enters judiciary. In fact, I want to tell you with great deal of emphasis that these civil judges at the age of 26, 27, when they enter judiciary, they are paid more than what a fresh IPS officer or IAS officer is given. I think their salary is about 80,000. So 15,000 more a judicial officer gets. And one more departure I make from today's topic. That departure is that today we have a scenario where almost in all states, if we consider the number of judicial officers who are appointed as civil judges, more than 50% are women. That's a remarkable change which we have seen. And in fact, the change was so drastic that in Bombay High Court, you know, after you are appointed as a civil judge, there is 1 year training in our judicial academy. So then divided into 3 parts, course for 4 months each, then you go back, work and again come back. So we had to amend our rules and we had to provide that if a newly appointed judicial officer has a child, we allowed either the mother of the judicial officer or mother-in-law of the judicial officer to stay in judicial academy so that child can be taken care of. The judicial officer, woman judicial officer can undergo training without any tension. So this is a very remarkable change which I have seen personally happening in judiciary during last about 10 years. And I'm not talking about states like Maharashtra, Gujarat, Karnataka, which are said to be progressive states. I went to deliver a lecture in Judicial Academy in Bihar about 3 years back. There, during last 3 years, 63% of the judicial officers appointed are women. And that's a remarkable feature, a remarkable change which I have seen. Another change which I have seen in legal education is I must have presided over these moot courts or mock trial competitions, practically hundreds of such competitions. And now during last 10 years I find winners are always girls and only by exception that boys win. So this is a change. So therefore it is very necessary for some of you to think of joining the traditional legal practice and thereafter judiciary. Because this is actually the challenge faced by the legal system, that we have talent, we have good intelligent law graduates, but they choose to go to firms and companies. And there are other reasons also why the cases get clogged up. One good reason, or bad reason I'll call it that way, is we have huge pendency of bail applications. The reason is that the police and the law enforcing machineries have forgotten the basic principle why a person is detained in jail till the conclusion of trial. In fact, some of you must have read great judgment by one of our greatest judges, Justice Krishna Iyer, where he says that in Indian criminal jurisprudence, bail is the rule and jail is the exception. Of course, there are exceptions to this rule where there are very stringent offences like NDPS Act, offences concerning the drugs, or Prevention of Money Laundering Act, or UAPA, where terrorists are involved. There the bail conditions are stringent. Today we have a scenario where in a clear case where accused must be granted bail, the courts are not granting bail, and therefore they have to travel all the way up to Supreme Court. And there are reasons for this. The reasons are that there are local pressures. And what are those local pressures? I will tell you a very interesting thing. Unfortunately, after 75 years of existence of Constitution, we have offences against women, very, very serious offences against women. Then police arrest somebody by showing him as accused. And we have political leaders who go on public platform and say that will ensure that the man who is arrested is hanged or he is severely punished. When political leaders say this, they forget that whether a person is guilty or not, that can be decided only by the court of law, that also after entire trial is over. But these political leaders, for whatever reasons, they say so. Then in our society there is complete lack of knowledge about the law. In fact, I personally feel that one of the greatest challenges which our society faces today is lack of legal literacy. Forget about knowledge of law. Now some of you must be working in legal aid projects. You go to villages and ask the villagers, forget villages, go to in cities also and ask people, do you know what is fundamental right? Do you know what is fundamental duty? You will find that majority of people will not be able to answer the question. So lack of legal literacy is major challenge, and therefore when court grants bail to an accused, there is criticism of the courts that why bail has been granted in such a serious offence. Because common man does not understand, why common man, even educated class does not understand difference between grant of bail and acquittal in a case. So you go to any court, High Court, Supreme Court, or any court, you will find that there are large number of bail applications. If you go to Supreme Court, I am sure some of you must have visited Supreme Court. On Mondays and Fridays, which are admission days when fresh newly filed matters are considered, you will find that on the causes of every court, about 25% of SLPs arise out of orders refusing to grant bail. So people have to go up to Supreme Court. So this is also one important reason that our system gets clogged because of bail applications. Another reason is lack of infrastructure. I'll give you an example of Nashik. Now there is a new building constructed which was inaugurated by erstwhile Chief Justice of India. You must have seen the situation in Nashik court before that building was constructed. It was horrible. There used to be so much of congestion in courts, there was no place for parking. And notwithstanding persistent demand, government refused to give land which was available. And then High Court had to issue a writ of mandamus directing the government to give land. That was done long back. Now you have that very state-of-art building. You go to some of the taluka courts or some of the district courts in our state, you will find infrastructure is pathetic. Go to Pune court, for example. Some of the civil judges don't have independent chambers. They sit in a small room. Between 11 to 5, that small room becomes the court, and rest of the time it is their chamber. litigants don't have facilities. In so many courts, taluka courts, if you go there, you will find that there are not even separate washrooms for women lawyers and women litigants. So there is complete lack of infrastructure. In one of the books written by Arun Shourie, he has lamented upon it, the status of infrastructure in our court. Now we talk about Tariq pe Tariq. There is one shocking aspect of this. You know, for criminal trials, you need a prosecutor, because prosecutor is a lawyer who conducts the case on behalf of the state government. In many states, even some parts of Maharashtra, we find that for 2 or 3 courts there is only one public prosecutor. So therefore, if public prosecutor is conducting trial in one criminal court, sometimes the trial involves examination of 4 to 5 witnesses, more witnesses, then arguments. So if you have one prosecutor for 2 or more courts, if he is conducting trial in one court, the other courts have to grant adjournment, courts have to give dates. Now if prosecutors are not available, what do we do about this situation? Cases have to be adjourned. It's not only about prosecutors, it is about availability of government advocates also. In number of courts, because number of the government advocates are inadequate, dates are given. So there are reasons and reasons. And of course, one contribution, there are 2 other contributors to this huge challenge which we are facing today. One is the role of the judges. I have been part of the institution, therefore I can candidly say that even we the judges, we are not able to perform the way it is expected of us. And one of the reasons is that we have to deal with so many cases every day. So judges undergo fatigue. Now there is a criticism. When we are talking about challenges, there is a criticism that why our courts have so many holidays. That criticism is very common criticism. I have attended various workshops of doctors, legal workshops of doctors, chartered accountants and other tax professionals. They always complain that why you people take so many holidays. Ideally, yes, we should not be taking so many holidays. Now let us talk about trial and district courts. How many holidays the judges get? In Maharashtra, they get holidays on every Sunday and 2nd and 4th Saturday. You talk to any judicial officer, some of you must be going to observe the proceedings. Out of these 6 holidays every month the judges get, at least half of the holidays are consumed in attending local honors, legal service authority work, legal literacy workshops. So half of the holidays go. There is popular misconception that our courts are completely closed in vacation. For example, in courts in Maharashtra, trial and district courts, we have 4 weeks vacation. But that vacation is available only to civil courts, it is not available to criminal courts. And judges get vacation only 2 weeks out of those 4 weeks, and criminal courts function normally. Now let us talk about the Supreme Court. Supreme Court works on 190 days. And we have that long break, summer break, where 3 benches work normally. I will give an example of topmost court in USA. Topmost court in USA works for 69 days in a year, and they deal with 300 to 400 cases every year. Whereas every bench of the Supreme Court every week deals with 250 cases minimum, between 200 to 250 cases. Now there is a fashion to talk about legal infrastructure in Singapore. Firstly, in Singapore, if it comes to this criminal jurisdiction, there are kangaroo trials, in the sense that there is hardly any opportunity for an accused to defend. Once you are named by the police, it's very difficult to get out of clutches of the law. But there, the topmost court, Supreme Court, they work for 1 week. They take 1 week's break to apply their mind. Then they again work for 1 week, and week thereafter they take time to, they don't sit in the court to write judgments. So there is justification in that criticism that there are too many holidays. But young students, you mark my words, next year when Supreme Court reopens in July, please see the cause list of the Supreme Court for first week after the court reopens. You will find that large number of very heavy judgments are delivered by the judges, because we use the vacation to write judgments. In fact, I can tell you, I was judge of the Bombay High Court for 15 years and 9 months and 2 years and 4 months as Chief Justice. In May vacation, I never got holiday of more than 7 days in May or April, whatever is the vacation. But still, people criticize us for taking holidays. Now, this is one thing on which study is required, that how much working hours the judges are putting in, because you see courts take between 10 to 5. Supreme Court or High Court, for example, at Bombay High Court also, my experience is that we require at least 7 hours a day after or before the court hours to read the files and to correct judgments, to correct the orders which we pass. And Saturday, Sundays is only work, nothing else. And our duty is that as judges we go and deliver lectures in law colleges, we address the legal aid seminars and all. So this is also one of the causes attributed to delays, the holidays. And I must tell you very interestingly, as the Chief Justice in Karnataka, in meeting with the Bar Association, I said that can we reduce the summer vacation of High Court by 1 month. There was strong opposition by members of the bar, because their viewpoint is that when court functions they can't go out. But it's not like doctors, that doctors can keep a local, somebody else looks after their practice. This cannot be done by lawyers, because legal profession is a highly personal profession. You realize, those who join legal profession, that ultimately people come to you because they have faith in you. They need not have faith in your colleagues who are working with you. So this profession works on personal faith. So this is a very complex issue, but still, as a student of law, I must say that this is one issue which is stated to be contributing to delays, huge delays. Now, when we discuss failure of our legal system, which is reflected from the figures which are available, I want to give you another angle. There is a preamble of the Constitution, there are fundamental rights, there are fundamental duties. But today in India, we talk about progress, we talk about development. But even today, there are a large number of citizens who do not approach the court, though they suffer injustice. They silently suffer injustice. The reason is poverty, the reason is social condition, the reason is that the remedies which they have to adopt by going to the court, sometimes the remedies are costly. The legal aid network, legal aid is now part of the fundamental right, especially in case of accused. The legal aid network, we are not able to develop that effectively. So there is large population, especially women. Some of you must have read that old IPC section 498A, where woman alleges that because non-payment of dowry, the in-laws and husband is harassing her, causing cruelty to her. And it is commonly said in our society that, this provision is being misused. False cases are being filed by women. There may be element of truth. Those cases which have come to the court, some of them may be false cases. But today we have a scenario where a large number of women in our country silently suffer cruelty. They even can't think of approaching the court. They can't even think of approaching the police for registration of complaint. So one challenge before our legal system is that the system is clogged and we have a huge pendency. But equally the other challenge is, so I always say this, that we call cases as dockets. So there is a docket explosion. This is explosion only. So many cases, 4.88 crores cases pending in India in various courts. But real worry is about docket exclusion, that we are keeping large sections of our society away from justice. They can't approach the justice delivery system. I request some of you, if you get opportunity to visit the jails, As chairperson of the Legal Service Authority of Maharashtra, I had visited many jails, many central jails, including Nashik jail. Now look at the status of the prisoners. They are 80%, 70% of them are under trial. They are not found to be guilty. Their trial is pending, therefore they are in jail. See their pathetic conditions. Some of them can't afford a lawyer. Some of them get legal aid lawyer, but legal aid lawyer is not competent. It doesn't cross-examine the witnesses properly. I remember going to 2 or 3 central jails where prisoners told me, some of the prisoners told me that, sir, I am under trial prisoner say for 9 years or 10 years, and look what is happening to my family. Assume that I may have committed an offense and therefore I am in jail for 10 years without trial. But I face practical difficulty. I can't get my daughter married because of stigma against me. There is nothing wrong with my daughter. Somebody said that my son is not getting employment as a result of the fact that he was in jail. So this is the kind of injustice which people suffer. And students can do so many things. Students can do so many things as paralegal volunteers. There are issues and issues. I'll tell you one issue. For setting up a nuclear power plant in Palghar district of Thane, 2 villages were completely uprooted. The entire land was acquired. The government set up 2 new villages, houses and all, under the same name, and villages were accommodated there. Now there are no facilities. There are no nearby agricultural land, no facilities of education, then medical aid. So I requested students of National Law School at Mumbai. We gave them questionnaire, we told them to go there for 2 days and talk to the villagers. Through Legal Service Authority, we are monitoring the rehabilitation of those poor people. And I used to hold meeting with Secretary of the Nuclear Energy Department, the collector, the commissioner. It was not effective, but young students went there. They studied the whole thing, they prepared a PowerPoint presentation. And I showed that PowerPoint presentation in presence of Secretary of the Atomic Energy Department. And that was so effective that the Secretary of the Atomic Energy Department said that now I have learned where we have gone wrong, and therefore we will release large number of funds. Another example which I always tell in every law college, for a Legal Service Authority function, I was in Pune. I was coming back by car to Bombay. I received a phone call on my cell phone by a woman. In 2017, you must be very young, but in those days, there are newspaper reports that unless you have Aadhaar card and you link that Aadhaar card with your bank account, you won't be able to operate bank account. So she was a widow and her one arm was amputated for medical reasons. So with some help sitting on a wheelchair, she went to Aadhaar center. And these people said, sir, madam, you can't get Aadhaar card because we need impression of all 10 fingers. So she was so agitated. She said, what is this happening in our country? I am a widow, my bank account will be closed, I can't get Aadhaar card. So I spoke to one of the professors of law colleges in Pune. The professor said, I will depute some paralegal volunteers, young students there. So young students, they work magic. I think in a group they went to that office where Aadhaar card was issued. I don't know what they did, but within 6 to 7 days, a team of officers went to the house of that lady. That entire formality was done. Impression of only 5 fingers was taken, and within 2 days, Aadhaar card was delivered at doorsteps. This was done by paralegal volunteers. I have seen paralegal volunteers doing a great job. So if you have opportunity to work as paralegal volunteers, if you have opportunity to work in legal aid project, maybe by visiting a jail, by visiting slums, please undertake that work. That will give you not only great satisfaction, but it's such a learning experience. Such a learning experience to go to jail, such a learning experience to go to a slum or a locality of hutments. And that's very, very challenging. Now lastly, before we start our interactive session, the idea of choosing this subject is that young students must know what are the challenges before our legal system. And that challenge is also a challenge before our young law students and young law graduates. Now they have to accept the challenge, they have to enter the legal profession. Some of you must think of joining judiciary because it's a huge challenge. And when you have a huge challenge, you accept that challenge. It's a great pleasure to accept such challenges and work under adverse circumstances. And I am telling you that if you join traditional legal profession, it may be 2 or 3 years will be very hard for you, especially those who are first generation lawyers. But once you show hard work, you show patience, I am assuring you that nothing succeeds like a success in profession of law. So please keep that option open of joining traditional legal profession and thereafter joining judiciary. So I think 1 hour's time is over. I thank all of you for giving me patient hearing. Now we can start with our interactive session. Now I am telling you 2 things. One is questions on all topics are welcome. You can ask questions in Marathi, English, Hindi. I'll be able to answer that. You can ask questions in Gujarati also, but I'll answer in English. I'm not that fluent in Gujarati. So let us start with our brainstorming session now.
Thank you so much, sir, for your enlightening session. Please raise your hand if you have any doubts, and the volunteers will.
Working? Before you ask questions, I want to ask you one question. How many of you want to join traditional legal profession? Please raise your hands. So good numbers. And how many of you intend to take up career in judiciary? Good, good. At least there are reasonable number of hands. Now we can start with the session. Yes.
सर माझं नाव अक्षय दिलीप जाधव. माझा क्वेश्चन असा आहे की सध्या ज्युडिशरी सिस्टीमकडे बघता मला किंवा माझ्या कलिगला असं जाणवतंय की ज्युडिशरी सिस्टीम जरी इंडिपेंडेंट असेल तरी गव्हर्नमेंटचा काहीतरी त्याच्यावरती प्रेशर असतो असं आम्हाला जाणवतंय. तर हे आहे असतं का म्हणजे लीगलमध्ये की नाही तसं काय प्रेशर ज्युडिशरी सिस्टम घेत नाही?
मी 2 गोष्टी तुम्हाला सांगतो याच्याबद्दल. आर देअर एनीबडी हू कांट अंडरस्टँड मराठी? Okay, so I'll talk in English. See, firstly, I must tell you, I have worked as a judge in 3 constitutional courts for 21 years, 9 months and 25 days. Personally, I have never experienced any pressure from any quarter. The only pressure is to decide correctly. Secondly, if you have that impression, you know, it's a matter of study. I always say that every citizen of India has right to offer constructive criticism of the judgments of the courts or conduct of the judges, public conduct of the judges, not the private conduct of the judges. So you are entitled to have this impression that government is able to pressurize. Maybe in terms of collegium recommendations, government keeps names of good candidates pending for a year also. And there are instances where though the recommendation for appointment as a judge of the High Court is cleared by Supreme Court Collegium, it takes 1 year also. And then some candidates withdraw their consent. To that extent, interference is definitely there. I said so in one of my judgments also. But if you feel that certain decisions of the court have been influenced by maybe pressure or maybe influenced by the government, then you should be able to pinpoint those judgments. That after reading the judgments, you feel that because judgment is written in a particular manner or a particular view is taken, there is possibility that government's influence cannot be ruled out. Because you are a law student, so therefore you must study the judgments and then say that look, these are the 5 or 6 judgments. And this criticism is there. I tell you, in Supreme Court Bar Association, I arranged my lecture. Somebody invited my attention to statement made by the financial advisor of the Prime Minister of India. He said that the judgments of the courts are coming in the way of Vikasit Bharat. So I only said that that he's a great learned man. That learned man should tell us which judgments have come in the way of Vikasit Bharat, so that we who belong to legal fraternity will study those judgments, and if we find that we have gone wrong, we'll accept that we have gone wrong.
हॅलो सर माझं नाव राहुल गायकवाड. 3 घटना आहेत ज्यामुळे भारतीय न्याय व्यवस्थेबद्दल सर्वसामान्यांमध्ये उदासीनता दिसून येते किंवा उदासीनता होऊ शकते. पहिले जे आहे की महाराष्ट्रामध्ये जे सरकार मागे होतं त्या सरकारमध्ये जे पक्षाची फूट झाली त्याची केस अजून पेंडिंग आहे. दुसरं एका सरकारची पूर्ण कालावधी पूर्ण झालेला आहे. अशा परिस्थितीमध्ये त्याचा निर्णय येत नाही, तारीखवर तारीख चालली. दुसरी गोष्ट नॅशनल सिक्युरिटी ऍक्ट आणि UAPA ऍक्ट ज्याचा सरकार सातत्याने दुरुपयोग करतं आणि त्यामध्ये 5 वर्ष झाले. एक तरुण आहे उमर खलीद नावाचा, त्याला जामीन भेटत नाही, आता भेटला त्याच्या बहिणीच्या लग्नासाठी फक्त. तर 5 वर्षासाठी त्या केसेसमध्ये जी ट्रायल झालेली आहे ते अजून ट्रायल सुद्धा सुरू झालेली नाही. अनेक वेळेस जजेस गैरहजर राहिलेले, अनेक वेळेस गव्हर्नमेंट ज्यांनी केस दाखल केली ते गैरहजर झालेले. म्हणजे त्यांनी जर गुन्हा केला असेल तर ट्रायल तरी सुरू व्हायला पाहिजे. अशा परिस्थितीमध्ये न्यायालय काय भूमिका घेत आहे. तिसरी गोष्ट म्हणजे जस्टिस, आता उच्च न्यायालयाचे जस्टिस UPचे असतील बहुतेक, त्यांनी असं स्टेटमेंट दिलेलं आहे की स्तन ओरबाडणे, ओढतणे, पायजमाची नाडी ओढणे याला बलात्कार किंवा बलात्काराचा प्रयत्न असं म्हणता येत नाही, अशा प्रकारचं स्टेटमेंट दिलेलं आहे. या सर्व गोष्टी ज्या आहेत ते जेव्हा आपण बघतो की ट्रायल झालेले आहे, तारीख ते तारीख चालती, ही लोकांना सवय झाली. परंतु ह्या ज्या घटना आहेत ज्या माइलस्टोन सेट करू शकतात जनसामान्यांमध्ये, तर याच्यावर न्यायालय काहीही भूमिका घेत नाही असं जर मत सर्वसामान्यांचं झालं तर आपण काय करायचं.
I'll start with the last topic. You refer to a judgment or view taken by the court, it is wrong. I mean, anybody will say who is part of the legal system, it is wrong. No doubt about it, and there are several wrong judgments. But as a student of law, you must also see positive side of it. I'll give one example. Vishakha judgment by the Supreme Court. There was no law in force. Vishakha judgment created a machinery where there was harassment to women at the workplace. Second, you are right that in some cases bail is delayed, but I am party to several judgments under PMLA and UAPA where we have taken a view that even if the conditions prescribed by law are very stringent, if there is inordinate delay in holding trial for no fault on the part of the accused, unless there are grave incidents attributed to him that he is offender, he is offense, in other cases I am proved, he is entitled to bail. In fact, in PMLA, we have taken a view that maximum sentence is of 7 years. So if a person remains in jail and under trial for 1 year or 1.5 years and trial is not likely to commence, he must get bail because maximum sentence is 7 years. But to cases which you referred, you are right. The hearing of bail applications were delayed and now Supreme Court is hearing it. I think the case has been concluded. But of course, I can't deny that there are cases where bail should have been granted, bail ought to have been granted, bail has not been granted. What was the first topic you said? First? Maharashtra government, correct. So there also, this criticism, those who make criticism, they are entitled to make that criticism. And those who make criticism may be right also. But you must also apply your mind. I think that case is pending from 2022. It was filed, I think, in 2022 or maybe beginning of 23. I don't recollect exactly. Now you must also find out in those days what kind of cases were heard by the court, how many bail applications were heard by the court, how many important cases dealing with environment, pollution, forest, how many cases were heard. So ultimately it's a Supreme Court where now pendency is 90,000. So when you say that a particular case is not heard, you have to consider in a context how many other important cases were heard by Supreme Court during this period. Cases involving liberty, cases involving offences against women and environment matters. So many important cases were heard. Of course, that does not mean that that case should not have been heard. But ultimately, you have to see such things in a context. in a context, because ultimately you must study in what manner Supreme Court is functioning, which are the category of cases which are being taken up. And if you feel that cases which are inconvenient to ruling party are being delayed, then that's the matter of study. Then you must find out how many are such cases. First you must find out the cases which were taken up by the court, whether those cases were not inconvenient to ruling party, and how many cases which are inconvenient to ruling party are not taken up. But that criticism is justified. But when a law student makes such criticism, I expect you to make a wider and deeper study before you make those allegations.
माझं नाव प्रमोद कांकरिया. आजचा आपला विषय होता तारीख पे तारीख. याला कुठेतरी वकील सुद्धा जबाबदार आहेत का? कारण का वकिलांनी त्यांचं जे प्रोफेशन आहे ते त्या पद्धतीने पूर्णपणे निभावत आहेत का, या संदर्भात काही माहिती?
सी मराठीत एक म्हण, एका हाताने टाळी वाजत नाही. सी अल्टिमेटली इट्स ए कलेक्टिव्ह एफर्ट ऑफ जजेस अँड लॉयर्स. Judges on their own can't reduce the pendency or can't deal with the cases expeditiously. Lawyers also contribute. Sometimes there are unnecessary adjournments. More than unnecessary adjournments, there are long arguments. There are long cross-examinations, unwarranted cross-examinations. So lawyers have also contributed. I am not saying no. So when we say about judicial delays or huge pendency, the entire legal system must take blame. Legal system consists of lawyers and judges. So even lawyers must take blame. There are cases and cases where they contribute to the delay.
माझं नाव मिलिंद जाधव आहे. BNSS 2023 मध्ये सेक्शन 20 जे आहे त्याच्यामध्ये डायरेक्टर ऑफ प्रोसिक्युशनची त्याच्यामध्ये नेमणूक करण्यात आली आहे. पूर्वी डायरेक्टर ऑफ प्रोसिक्युशन हायकोर्ट ऑफ चीफ जस्टिस ऑफ हायकोर्ट बॉम्बे च्या रिकमेंडेशनने त्याची नेमणूक करण्यात येत होती. परंतु आता डायरेक्टर ऑफ प्रोसिक्युशन जो आहे होम मिनिस्टरने त्याची अपॉइंटमेंट करणार आहे. आणि होम मिनिस्टर स्टेट गव्हर्नमेंटचा होम मिनिस्टर डायरेक्टर ऑफ प्रोसिक्युशन नेमणार, डेप्युटी डायरेक्टर ऑफ प्रोसिक्युशन नेमणार आणि असिस्टंट डायरेक्टर ऑफ प्रोसिक्युशन नेमणार. आणि त्यांनी त्या केसेस बी बघून दिल्या की 10 वर्षाच्या केसेस यांनी बघायच्या, 10 वर्षाच्या, 15 वर्षाच्या यांनी बघायच्या, 7 वर्षाच्या. आणि असं त्यांनी म्हणजे हायकोर्टला त्यांनी बायपास करून होम मिनिस्टरनी हे सगळं पॅरलाइज केलं. मग याचा अर्थ आपण जे ज्युडिशरी सेक्टर किंवा इंडिपेंडेंट म्हणतो, तर मग याच्यामध्ये ते होम मिनिस्टरचा इंटरफेअर आहे ना.
पहिली गोष्ट काय माहिती आहे का, आपण लॉ स्टुडंट आहात, तर मला असं वाटतं की आपण ह्याचा अभ्यास करायला पाहिजे की आता कायद्यामध्ये काय लिहिलेलं आहे, कायद्यामध्ये अपॉइंटिंग अथॉरिटी कोण आहे. आता कायद्यामध्येच गव्हर्नमेंट आहे. करेक्ट, रेकमेंडेशन ऑफ बॉम्बे हायकोर्ट. बरोबर आहे की नाही. म्हणून ह्याच्याकरता काय पाहिजे, ह्याच्याकरता ही जर ॲक्शन इलिगल असेल त्याचा अभ्यास करून कोणतरी त्याच्याबद्दल PI दाखल करायला पाहिजे, कोणतरी कोर्टामध्ये रिट पिटिशन दाखल करायला पाहिजे. कसं असतं माहिती आहे का, आपल्याकडे अनेक बेकायदेशीर गोष्टी घडत असतात, पण प्रत्येक बेकायदेशीर गोष्टीची दखल न्यायव्यवस्था आपण घेऊ शकत नाही, कारण न्यायव्यवस्थेकडे ऑलरेडी हात बांधलेले आहेत. तर त्यामुळे हा तुम्ही विचार करता ही फार चांगली गोष्ट आहे. पण तुमची अशी खात्री झाली असेल कायद्याचा पूर्णपणे अभ्यास करून की ह्याच्यामध्ये बेकायदेशीर काहीतरी केलेलं आहे, तुम्ही दाद मागायला पाहिजे. त्याच्यामध्ये दाद मागायला पाहिजे, हे महत्वाचं असतं.
पण हायकोर्टाचे होतात आणि त्याच्यात सुप्रीम कोर्टाचे ज्यावेळेला होतात त्यावेळेला आपल्या अनेक जजमेंट बघितले, खूप चांगले जजमेंट आणि खूप चांगल्या पद्धतीचे आलेले. लास्टमध्ये एक पाऊल येसू दासन जे आहे जजमेंट आपण दिलेलं आहे ते अतिशय सुंदर आहे. तर मला एक प्रश्न असा आहे की हायकोर्ट आणि सुप्रीम कोर्ट पोलीस मशिनरीच्या वर्सेसमध्ये अनेक जजमेंट देतात, पण तरी पण पोलीस मशिनरी ही सुधारतही नाही आणि आजपर्यंत सुधारल्याने जाणवलेलं नाही. प्रत्येक जण आपल्या अधिकारासाठी पोलीस स्टेशनमध्ये लढत असतो. तर याच्यावर आपलं काय मत?
कसं आहे माहिती आहे का की आता पोलीस मशिनरी सुधारणं हा सुद्धा ज्याला आपण मगाशी म्हणून लिगल लिटरसीचा भाग आहे. आता पोलीस मशिनरीला ट्रेनिंग किती दिलं जातं, आपण मी ती मशिनरी जस्टिफाय करत नाही, कारण माझ्याच निकालात मी अनेक वेळा क्रिटिसाइज केलं. पण दुसरा पण भाग आपण विचार केला पाहिजे की आपल्याकडचे जे पोलीस असतात ते किती तास ड्युटी करतात. एखाद्या राजकीय नेत्याचा दौरा असतो त्यावेळेला 24 तास ते ड्युटी करत असतात. आपण नागरिक पोलीस मशीनला किती आपण दडपण आणतो. पोलिसांचं खरं काम काय आहे, कायदा आणि सुव्यवस्था राखणं आणि कोणतरी गुन्हा करत असेल तर त्याचे तपास करून ते प्रकरण तडीस नेणं. पण आपण आता इतक्या प्रकारचे आपण उत्सव करतो, सार्वजनिक उत्सव. त्या सार्वजनिक उत्सवाचं सगळ्यात जास्त दडपण येत असेल तर आपल्या पोलीस व्यवस्थेवरती येतं ते. तर आपण नागरिकही जबाबदार आहोत. पोलिसांचं ते काम आहे का की दहीहंडी, गणपती उत्सव, नवरात्र उत्सव याच्या वेळेला पोलीस बंदोबस्त त्यांनी करत राहायचा, हे त्यांचं काम आहे का? नागरिकांनी पण गंभीरपणे विचार केला पाहिजे. पोलीस मशिनरीवर आपण किती दडपण आणतोय, किती, ती पण शेवटी माणसंच आहेत ना. त्यामुळे जेव्हा पोलीस मशिनरी काहीतरी बेकायदेशीर करत असेल, कोर्टात त्याच्यावर नक्की कारवाई करेल, करायला पाहिजे. केली जात नसेल तर ते चुकीचं आहे. पण एक नागरिक म्हणून आपण विचार केला पाहिजे की आपण पोलिसांकडनं काय काय काम करून घेतोय सध्या, याचा आपण विचार केला पाहिजे. कारण एक आता मी मुद्दाम गोष्ट सांगतो तुम्हाला. घटनेचं 51वं कलम आहे, फंडामेंटल ड्युटी. त्या पहिली ड्युटी अशी आहे आपली की घटनेचे पालन करणं आणि घटनेचे जे आयडियल्स आहेत, आदर्श आहेत, त्याचा सन्मान करणं. आता घटनेचं पालन करणं जेव्हा आपण म्हणतो, ते घटनेने निर्माण केलेले जे कायदे आहेत तर ते कायद्याचं पालन करणं हे आपलं कर्तव्य असतं. आता उत्सवाच्या निमित्ताने नॉईज पोल्युशन रूल्स आहेत, आपण त्याचा भंग करतो. आपलं ड्युटी आहे ते कायद्याचं पालन करणं, ते आपण करत नाही. त्यामुळे पोलीस मशिनरी, आपण विचार करा, हे उत्सव असतात त्यावेळेला पोलीस मशिनरीकडे किती तक्रारी येतात. पण रस्त्यावर मंडप घातलाय, कोणतरी 10 नंतर लाऊडस्पीकर वाजवतोय, कोणतरी डीजे वाजवतोय. तर त्यामुळे नागरिकांनी, आपण जेव्हा पोलिसांना ब्लेम करतो तेव्हा नागरिकांनी पण खऱ्या अर्थाने विचार करायची गरज निर्माण झालेली आहे की तिथे पण अपुरी संख्या आहे. आपण पोलीस स्टेशनला जर कधी गेलात तर आपण जरूर बघा, साधी तिथे म्हणजे वॉशरूम चांगल्या नसतात तिथे पोलीस मशिनरी. बघा तुम्ही, अनेक पोलीस स्टेशन अशी आहेत की जवळपासच्या दुकानात ते पोलीस लोक हे वॉशरूम वापरतात तिथे, दुकानातले किंवा आजूबाजूचे जे हे असतात, रेस्टॉरंट असतात तिथे. त्याचाही आपण विचार केला पाहिजे. न्यायालयाने कठोर कारवाई करायला पाहिजे, शंका नाही, पण दुसरी बाजू आहे त्याचा पण आपण विचार केला पाहिजे. बराच वेळ उभे आहात, त्यांना विचारून दे, बराच वेळ उभे आहेत ते. सिनियर सिटीजन्सना नेहमी आपण मान दिला पाहिजे.
तर माझी जी केस आहे ही एसबी कोर्टातून वर्सेस स्टेट ऑफ महाराष्ट्र, ही 77
मला वाटतं आपण इंडिव्हिज्युअल केसेसवर डिस्कशन करायला नको.
तर लार्जेस्ट केस आहे की 77 ला जजमेंट आलं सुप्रीम कोर्टाकडनं, त्याच्यानंतर गव्हर्नमेंटने हे तरी इम्प्लिमेंट केलं नाही. 81 ला पण हायकोर्ट मुंबईमधून डायरेक्शन्स मिळाले, मग त्याच्यानंतर गव्हर्नमेंटने नवीन रूल्स केल्यानंतर सुद्धा त्याचं इम्प्लिमेंटेशन नीट होत नव्हतं. मग पुढच्या काळात आणखी केसेस झाल्या, म्हणजे 90ला सुप्रीम कोर्टात परत 5 जज बेंचची केस लागली, म्हणजे कॉन्स्टिट्यूशन बेंच लागला, त्याच्यावर सुद्धा इम्प्लिमेंटेशन जवळ विशेष काही होत नव्हतं. मग छोट्या केसेस गेल्या 98 पासून तर 2005 पर्यंत. 2005 ला हायकोर्ट मुंबईने परत जजमेंट दिलं, त्याच्यावरती गव्हर्नमेंटने 70 to 92 पर्यंत पार्टली इम्प्लिमेंट केलं आणि परत इम्प्लिमेंट केलं नाही. आता परत लेटेस्ट मॅटमधनं पण जजमेंट आलं, आता परत त्याला चॅलेंज परत गव्हर्नमेंटने हायकोर्टात केलं. तर ही केस सुरू झाली 77 पासून. आय रिक्रुटेड इन 85 किंवा माझ्यासारखे बरेच. तर इम्प्लिमेंटेशन जवळचा सरकारकडनं काही केलं जात नाही किंवा विरुद्ध केलं जातं. तर ह्याला न्यायालय काय करू शकता हा प्रश्न माझ्या.
एक साधी गोष्ट आहे त्याच्याकरता,
बरेच लोक रिटायर्ड झाले.
नाही कंटेम्प्ट ज्युरिडिक्शन आहे त्याच्याकरता.
हो, मग कंटेम्प्टसाठी मी मुंबई हायकोर्टात गेलो होतो, पण त्यांनी मला सांगितलं की गो टू द मॅट.
का बरोबर, मॅटला जर सरकारी नोकर असले मॅटला ज्युरिडिक्शन आहे.
हो, मॅटला, परंतु ही केस इतकी जुनी आहे. हायकोर्ट, सुप्रीम कोर्ट होऊन 5 जज बेंच नेमून परत एकदा मुंबई हायकोर्टातून 2005 ला क्लिअर डायरेक्शन दिले, पण ते फॉलो होत नाही. तर मला प्रश्न असा विचारायचा, ज्युडिशियरी इज डुइंग वेल, म्हणजे सगळे जजमेंट्स इन लाईन आणि बरोबर एकमेकाशी जोडलेले आहेत, परंतु जर ऍडमिनिस्ट्रेटिव्ह लेवलला जर होत नसेल काम तर ज्युडिशियरीकडे.
आता काय माहिती का, तुम्ही एका पर्टिक्युलर इश्यू बद्दल बोलताय. आता नेमक्या कोर्टाच्या डायरेक्शन काय होत्या, त्याचं स्वरूप काय आहे, हे सगळं बघावं लागेल. त्याशिवाय इतकं असं जनरली मला सांगता येणार नाही की सरकार पालन करत नाही म्हणजे काय करत नाही. कारण डायरेक्शन अनेक प्रकारचे असू शकतात. कधी कधी डायरेक्शन अशी असते की पॉलिसी फ्रेम करा, डायरेक्शन अशी असते की रूल्स फ्रेम करा. त्यामुळे ही इंडिव्हिज्युअल केस आहे, ती केसचे
सेटल्ड आहे. जे डायरेक्शन 2 ओळीचेच आहेत फक्त, ऍज पर की प्रमोशन्स करा ह्या रूल्स प्रमाणे की गव्हर्नमेंट.
त्याच्याकरता तुम्हाला ऍडमिनिस्ट्रेटिव्ह ट्रायब्युनलवर जाऊन तुम्हाला कंटेम्प्टचा अर्ज करावा लागेल. त्याच्याकरता कंटेम्प्ट ज्युरिडिक्शन आहे त्याला एन्फोर्स करण्याकरता. जी रेमेडी आहे ती रेमेडी तुम्हाला आता तसा वापर केला पाहिजे.
Good afternoon, sir. My name is Archana. I wanted to know the opinion of yours on the judgment of that 3-year practice rule after this thing. So I wanted to know, you just discussed that judge population ratio is very low in India. Don't you think that judgment is also indirectly, promoting it?
See, there are two views possible in that. First, it is judgment of the Supreme Court now. Of course, when it comes to judicial service, such judgments are actually reconsidered after a span of time. One point of view is there's some merit in that. See, earlier, those who have not seen even the court in action, they used to become judges. Now, if you don't know how the court functions, you have not even seen how the court functions. You don't know what are the etiquettes followed by the judges and what are the etiquettes followed by the lawyers. And if you sit there as a judge, there are limitations on you. That is one point of view. The other point of view is, of course, that these 3 years are very crucial, and not that everybody who aspires to become a civil judge will really go and practice in the court. Maybe 1 year he'll attend coaching classes for appearing for examination. So there is a view and counter view. Only one thing which I personally feel, of course I can't say that judgment is wrong because it's a judgment of the Supreme Court. I personally feel that some concession should have been given to the women, because this age is a very crucial age. Maybe somebody may get married during that period. So that's what my personal opinion is, that 3 years is worth experimenting, but some window should have been kept, some concession to women candidates should be given. That's what my personal view is.
Thank you, sir.
And there is one more counter thing which I forgot to tell you. In 50s, there was a rule that one who stands first in LLB examination, he was directly offered post in judiciary. And there is a counter argument. I know some of the judges because I have practiced before them. Counter argument is that those who were appointed in those days, having no experience in practice, they did phenomenally well. But of course, they were toppers in LLB.
गुड आफ्टरनून सर।
Yes.
मेरे 2 क्वेश्चन थे। फर्स्ट इज मतलब 2010 से जो दिल्ली सुप्रीम कोर्ट में चालू है केस है, जिसमें जो विजुअली चैलेंज पीपल है उनके लिए गाइडलाइन बनाने जा रहे हैं वो, जिसमें ऐसा है कि कंप्यूटराइज एग्जाम देने के लिए वो एग्री कर रहे हैं, लेकिन अब कंप्यूटराइज एग्जाम में भी सर जो बैंकिंग में लोग हैं उनके लिए वो एग्री है। उसके बाद जो पुणे मुंबई जैसे जो सिटीज है वहाँ पे वो इम्प्लीमेंट हो रहा है, लेकिन जैसे कि नासिक है और बहुत सारे ऐसे सिटीज है जहाँ पे ये इम्प्लीमेंट ही नहीं हुआ है सर। फिर अगर आपको जब गाइडलाइन आपने बनाई है तो जो गवर्नमेंट या फिर जस्टिस जो भी है उन्होंने ऐसा करना चाहिए ना सर कि जो भी गाइडलाइन।
आप कौन सी केस के बारे में बात कर रहे हैं? कौन सी केस में डायरेक्शन
सर 2010 से वो केस चालू था। अभी 2019 में उसका रिजल्ट आया है।
You are talking about civil service exam or generally all exams?
No sir, generally it's all for educational and civil service.
Correct. No, that judgment I remember which is that judgment. That judgment needs to be carried forward. See, initially somebody felt that in all cities there may not be proper connectivity for holding examinations on computer, but now that judgment has to be carried forward. You are right, and I think some activists are working on that, because I dealt with several cases of visually impaired, those who had appeared for civil services, and eventually we had to pass order under 142 for granting them employment. And now a lot of work is happening, but you are right. I mean, that should be uniformly applied, and somebody has to move the court.
बट उसके बाद भी अब दिल्ली सुप्रीम कोर्ट में अब भी यही मतलब ये 2016 का गाइडलाइन है, उसके लिए 31 दिसंबर तक मतलब स्टे आया है ना।
That's right, because some decision of the government was challenged in the High Court, and High Court had granted stay. So remedy is to apply for vacating that stay. Remedy is available to apply for if that government's decision has been stayed, or decision of Delhi High Court is stayed by the Supreme Court. Remedy is to apply for vacating that stay.
So my next question is, अब मैं totally visually impaired हूँ और I want to become a judge of Supreme Court. And the thing is कि अब देखो जैसे कि बोलते हैं लोग कि केसेस नहीं आते और होता नहीं है पॉसिबल, तो क्या ये रियलिटी है, मतलब जब मैं जस्टिस के लिए अप्लाई करूंगी तो क्या ये पॉसिबल है?
See, basically you must remember how to become Supreme Court judge. See, you can become Supreme Court judge provided you are judge of some high court or you are a practicing lawyer before Supreme Court with some practice. Correct? So that is how you can become judge of the Supreme Court. Now, of course, you can aspire to become judge of a civil court now. And that is how you go in that channel. You become a district judge, and out of district judge also people are appointed to high court. So therefore, I think you should not have that very high aspiration of becoming judge of the Supreme Court. You must, for that purpose, you need to practice, you need to succeed. And there are good lawyers. For example, Mr. Runtha, senior advocate practicing in Supreme Court, he is also 100% visually impaired. Some young lawyers have started a firm in Delhi. I am in touch with them because recently there was an event in Goa arranged by Goa government and Goa Legal Service Authority dealing with the issue of lawyers who are visually impaired. So therefore, I really like the way you are thinking, but please get in touch with like-minded lawyers. There are good lawyers who are working in the field like Mr. Runtha. I forgot one woman lawyer in Bombay. Then there is young lawyer like Rahul Bajaj who is taking a lot of initiatives. So please get in touch with them. They will be able to help you.
Thank you, sir.
सर माझा प्रश्न आहे नमस्कार, माझं नाव संतोष गायकवाड आहे. आपण आज 75 वर्ष आपल्या राज्यघटनेला झालेली आहे आजपर्यंत. तर 75 वर्षामध्ये तुम्ही एक माजी न्यायाधीश म्हणून जी प्रवास बघितला न्यायव्यवस्थेचा, त्यात अजून काय सुधारणा व्हायला पाहिजे आणि तुमचा अनुभव काय?
तुम्ही सुधारणा तुम्हाला सांगितल्यास पहिली गोष्ट म्हणजे आपल्याकडे पुरेसे न्यायाधीश पाहिजेत, न्यायव्यवस्था पाहिजे, म्हणजे इन्फ्रास्ट्रक्चर पाहिजे. हे केल्याशिवाय, आणि मला नेहमी असं वाटतं की आपली तालुका आणि जिल्हा कोर्ट आहे त्याच्याकडे आपण जास्ती लक्ष द्यायला पाहिजे, कारण ती सामान्य माणसाची कोर्ट आहे. तर तिथून आपण सुरुवात करायला पाहिजे. तिथे पुरेसे न्यायाधीश पाहिजेत, त्या न्यायाधीशांना आणि वकिलांना पुरेशा साधनसुविधा पाहिजेत. तिथून आपण सुरुवात करायला पाहिजे. हायकोर्ट आणि सुप्रीम कोर्टाकडे आपण नंतर येऊया. पहिली गोष्ट म्हणजे ह्या न्यायालयांवर आपण आता लक्ष केंद्रित केलं पाहिजे.
75 वर्षामधला तो आधीचे जे सुधारणा कायदे होते, आत्ताचे जे कायदे आहे काही की ज्यात जसा तुकडेबंदी कायदा आहे, बाकी मी नाव देत नाही, पण त्यामध्ये तुम्हाला काय असं वाटतं की काय सुधारणा केली पाहिजे की जे पुढचे जे आपली जनरेशन आहे त्याच्यासाठी जास्तीत जास्त त्याला सुलभ होण्यासाठी?
See, actually what I feel is, barring few laws, I don't think any drastic amendments are required. What is required is the implementation of the laws. And 75 years, though I myself said that judiciary has not performed adequately, but still there are positives also. For example, PI jurisdiction. Relief was extended to common man under PI jurisdiction. And many cases, I gave example of Vishakha and many other cases. Yes, please.
Sir, you identified two areas where there is clogging of cases. One is the matrimonial disputes and another is the bail matter. Sir, what is your suggestion to remove this clog? I have heard of the work you did in the High Court relating to the premarital dispute. But as far as bail is concerned, you told one thing that local pressure, but as this judicial officers, why do they tell, other than this reason, is there any reason that they refuse bail, and also what can be done about it, both matrimonial as well as...
See, matrimonial, I'll tell you, that's a social issue. You compare matrimonial disputes in India with matrimonial disputes in developed countries. Now, in India, the moment there's a matrimonial dispute, it becomes adversarial. It becomes very bitter. In developed countries, if husband and wife have differences, they first go to a counselor. And many times the counselor suggests that all right, you part company. We call it golden handshake. That is not happening in India due to social reasons, because in India, marriage is not a contract in most of the religions. And therefore, If a woman is sufferer, I'll give an example. There are pressures on her from her own family, her friends, that why you want to break, why you want to go to breaking point. And then she suffers and she reaches a situation where it is impossible for her to reconcile. So main issue in matrimonial matters is that we are not able to create a machinery. Bombay High Court we tried. We told police that any woman who comes to file a complaint, the woman should be referred to that conciliation center. We had appointed good counselors from TISS and other institutions. So that before they go to the court, counselor will call both the parties and try to patch up. Either patch up or advise them to take divorce by mutual consent. So it is not happening. And once it goes to the court, it consumes time. And when matrimonial matter consumes time, bitterness develops in the mind of parties. So 5 years are spent. So one spouse feels that now I'll teach a lesson to the other one. Correct? And second, about bail. Bail, we are doing that effort. Now we are conducting classes for judges in our judicial academies. But we need to change the approach of the judges. So we are working on that.
So my experience as a lawyer for the little years I practiced was judges take bail as I beg your pardon and with due respect to the judiciary, they take it as a ego problem. They feel that this is something which gives them power, and for the serious cases bail is refused. And even the any restrictions put are very strange.
Very onerous conditions.
Means, it is, that brings me to a larger thing which I want to tell. In a particular case, I remember when there was the victim died of pneumonia and a dowry death case was filed. And the judge, first refused bail, and then when he granted bail, the sister-in-law who was staying 500 kilometers away, she had small children, and the child, he said that regular attendance to the police station was necessary. So when he said, when the lawyer put up the matter that there is small children, he said there is no problem, you can bring the child to the court, I will look after them. I mean, a judge, now comes the larger question is, the comments of the judge from the lower judiciary to the Supreme Court has a great impact on the ordinary man.
No, you are right. I mean, it's all about the approach adopted by the judges and approach adopted by the investigating machinery, because investigating machinery now feels that this is a way of punishing a person without guilt being proved. So a change of approach is required, there is no doubt about it. The way bail conditions are imposed, that also, we have delivered a long judgment. What are the bail conditions and what are not the bail conditions?
No, sir, about this mindset.
Mindset, yes, of course, improvement is required. Of course.
Academies, are they working
Yes,
on that?
yes. In fact, from last year, all judicial academies have been directed to conduct courses, refresher courses on law of bail. In fact, National Judicial Academy, we conducted a course for directors of Judicial Academy. I addressed them for 3 hours on that day. In what manner we can conduct the courses for judges dealing with bail. Okay, we can close now.
Yeah. At the outset, I appreciate the very clear and detailed session on the challenges before the ending judiciary. There is one particularly my scholar is doing work on block dates. The tripod test which has been laid down to the court is rarely being followed by the lower courts. There is one matter which came to me that I received a call that there are 40 students being traveled in the train from Narhar to Pune for madrasa, and 20 have been alighted at the railway station to Gosavi and 20 in Myanmar, and they will be taken to observation school. And 4 persons were carrying them have been arrested. On the first day itself, the trial judge remanded them for 14 days custody. If you look at the tripod test, which has been completely ignored, when the identity of all children was clear, when they were taken to the madrasa from home to the madrasa, there was no direct evidence that the terrorist activity is being done or kidnapping of them. But in the first installment, directly on the first day of appearance,
14 days, one day already gone into police station, and out of maximum 15 days, 14 days have been awarded. If you look at the trial, my scholar is also collecting the evidence, the judgments of the trial courts. So the likelihood of playing of the accused or interference with the witness, interference with the evidence is not being considered by the trial court. So whether a codified law plays a great way would help. What is your opinion on that?
See, what has happened is very unfortunate. No question of remand in such cases, but codified law will not help. Today also law is codified. There are well settled rules, but we are not able to follow that. And for the benefit of young students, I want to tell you one incident. In Karnataka, in one of the district places, there was a young student, 19 or 20 years old student. On 14th of August, I don't know why, but she shouted Pakistan Jindabad. She was taken into custody. And how a society reacts, because some citizens in that particular district place reacted strongly. Therefore, Bar Association passed a resolution that no one will take her bail application. I took sumo to cognizance of that. I issued contempt notice to the bar that this is contempt of court, saying that nobody should appear. And in fact, we directed their young lawyers from Bangalore. We granted them police protection and told them that you go under police protection and file a bail application there. On the first date, lawyers did not allow entry of their car. So next day we said now we'll direct arrest of the lawyers. Then of course Bar Association came, they apologized, they will do that resolution. So this is the mindset of our society. Why bar members reacted? Bar members are also citizens. Right? And so many cases which happen.
In the new BNSS, section 187, previously the maximum period for police remand was 15 days, but the provision says in exceptional cases it can go beyond.
Correct. That needs to be challenged.
No such case has come across.
No, but that needs to be challenged by someone. Any student? Any answer?
Sir, sometimes it is observed that the important judgments are passed at the end of the tenure of the Supreme Court Chief Justice. Like a judgment under regarding Article 200 recently passed by the former Chief Justice of India, the discretionary power of governor. Is it under political pressure or otherwise?
See, before you say that, of course, a citizen of India is entitled to say under political pressure. But have you studied the judgment and are you able to pinpoint how the judgment is legally wrong? See, as a member of the legal fraternity or a law student, your practice should be to read the judgment and then say how the judgment has gone wrong. See, as a law student, you should not go by perceptions. You should be able to study the judgment and say, yes, A, B, C, D, these are the reasons why judgment is wrong, legal reasons. You just can't draw inferences like that.
No, sir. My question is, the judgment is wrong or it is not my question, but it is passed at the very end of the tenure. That it was passed on the last day or day before last day.
See, I tell you one thing. That was on presidential reference. Now, President of India seeks advice. Priority has to be given. And we hear so many cases. If that is the criteria, I will tell you in the last month, I delivered 40 judgments last month. And last day, I pronounced 8 my judgments and 3 judgments of my colleagues. So, see, we have to finish the work. And therefore, we wait till last day to deliver judgments. So, more than that, you must study that judgment. It may be wrong, but you must say why it is wrong. One or two questions more we can close.
Two more questions.
Right.
So first of all, one meeting still. My only question to you is, you mentioned about paralegal volunteering. Could you please throw some light how to be a paralegal volunteer and what is the procedure to?
No, but you can talk to your professors. I mean, you can enroll yourself with the legal service authority. I mean, the procedure is very easy. That's right.